first topic is Mr. Eric Ng, who is the Deputy Secretary General of Hong Kong International Arbitration Center. Mr. Ng, prior to joining the Hong Kong IAC, Eric worked for 5 years as a barrister at law in Hong Kong. The topic he's going to share with us is Hong Kong IAC experience with BRI Disputes. Please, Eric. I pass to Eric.
Thank you very much to the Dashun Foundation for inviting me to attend today's conference and give a presentation in respect of HKIAC and BRI Disputes. As has been mentioned, my name is Eric Ng. I am the Deputy Secretary General of the HKIAC, and I'm very happy to be invited to give this presentation today. So just a quick overview for those who may not be familiar with what the HKIAC is, or the Hong Kong International Arbitration Center. We were founded in 1985. We were one of the first international arbitration institutions in Asia Pacific, one of the first regional international arbitration institutions. And over the past 30 years, we have essentially now grown to one of the top 3 arbitral institutions in the world, second only to ICC and the SIAC. We are an independent nonprofit organization, and we are a one-stop shop that provides both arbitration administrative services, but also hearing center services and assistance in both mediation, adjudication, and domain name disputes. We have a location here in Central Business District in Hong Kong, at Exchange Square, and we have a lot of experience in terms of providing support services and administrative services for hearings in and around Hong Kong. As I noted, we provide a one-stop shop for mediation and dispute resolution services, as well as adjudication. But primarily what you will know us for is in respect of our arbitration services, where we administer arbitration cases which are submitted to HKIAC either under our own HKIAC administered arbitration rules or the UNCITRAL arbitration rules. We are also the statutory appointing authority under the Hong Kong Arbitration Ordinance, and we also provide other services such as fund holding and tribunal secretary services. We have an extensive committee to show that we have a very extensive and well-managed corporate governance in respect of our arbitration services. 2 of the main committees which I wanted to talk about today are both our proceedings committee, which help make determinations in respect of anything underneath our rules or our ability to proceed with arbitrations, as well as our appointments committee, which deals with a lot of our appointments and other issues in relation to arbitrators and appointment of arbitrators. Our secretariat is very experienced. We come from 9 different nationalities, and we all speak about 10 different languages. Various amounts of experience in dispute resolution proceedings, both in terms of commercial arbitration, but also investor state arbitration. And we come from a mix of backgrounds, including common and civil law. Just a quick overview as to HKIAC's experience over 2021. We have one of the largest caseloads in Asia Pacific, and we registered around 514 new disputes in 2021. Of those, 277 of those disputes were arbitration cases, and 66% of those cases, or 183, were fully administered under either our rules or the UNCITRAL arbitration rules. We also did a significant amount in terms of domain name disputes and in terms of mediations. And this just gives a little bit of a different view as to total arbitration cases administered by our HKIAC over the past several years. We can see that we are seeing around a steady amount of cases around the past few years. And 2022 is looking much the same. And in fact, at the current pace, we are expected to have a record year this year at the HKIAC. One of the things we have taken pride in is in our ability to proceed with arbitrations under multiple contracts. And you can see that trend has continued to grow over the past several years as well. We are a very international center. And as you can see, we have parties in our arbitrations from around 41 different jurisdictions. Obviously, our top 10 users, most of our users do come from Hong Kong and mainland China, but we do see a significant number of users from the BVI, from the Cayman Islands, from the USA, from Singapore, from Korea, the UK, and from Japan. And so you can see that there is a wide disparity and a wide variety of jurisdictions in relation to the disputes which are submitted to HKIAC. Just some extra information for you in relation to the institution. 81.6% of our cases were international in nature. And what that means is that you have at least one party from a different jurisdiction from the other. 7.6% of our cases, in fact, involve no Asian parties whatsoever. There are, for example, disputes between US and BVIs or between two completely different jurisdictions. And 93.4% of our administered arbitrations were in fact international in nature. Hong Kong law is, for many reasons, the most commonly chosen governing law. But we also see a significant number of disputes under English law, under PRC law, and other various different governing laws as well. And the total amount of disputes in dispute for all of our arbitrations come up to about US $7 billion. So why would you arbitrate in Hong Kong or choose Hong Kong as a seat for your arbitration? Well, we are one of the top 3 most preferred seats in the world. According to the Queen Mary International Arbitration Survey, which was published in 2021, we are a top 3 seat in the world, and HKIAC is a top 3 arbitral institution. Hong Kong has both a modern and sophisticated legislative framework for arbitration, and we have an independent and pro-arbitration judiciary comprised of both local and international judges. One of the main reasons why you would choose Hong Kong is that you have access to interim measures from mainland Chinese courts. I'm going to talk about that a little bit more down the road. But what that means is that if you have an arbitration which is seated in Hong Kong and administered by a Hong Kong institution, you can access interim measures from mainland Chinese courts if, for example, you need to preserve evidence or you need to preserve assets in the mainland. We've also done a lot of work in respect of making sure that our arbitration legislation is quite modern. We've done a lot of work, for example, in making sure that third-party funding and outcome-related fee arrangements for arbitration are allowed and are accepted in Hong Kong. The third-party funding was approved and implemented into Hong Kong legislation in 2019, and we expect the outcome-related fee arrangements to come into force around 2022. There's also various other factors, such as choice of legal representation in arbitrators, world-class multilingual legal professionals, and strong expertise in disputes with Chinese elements. But more importantly, there is a strong track record of enforceability of awards, both in Hong Kong and Hong Kong awards abroad, which means that there's a level of assurance that when arbitrating in Hong Kong, that the award is binding and enforceable, no matter where in the world you are trying to enforce that award. Now, to speak a little bit more about the PRC arrangement on interim measures, which is one of the most important developments in the past few years in respect of arbitration in Hong Kong, PRC courts in the mainland can now order interim measures in aid of arbitrations which are seated outside of mainland China, but only if that arbitration is seated in Hong Kong and administered by a Hong Kong institution such as HKIAC. Now, we have seen since the interim measures arrangement came in 2019, we have seen 76 applications from the HKIAC. These are for applications for preservation of assets, preservation of evidence, and preservation of conduct. We've seen court orders granting over 13.3 billion RMB, or about 2.1 billion US dollars worth of assets in respect of these applications. And what we've seen learning from these 76 applications is that while the initial impression would be that this would be for foreign parties who are seeking to obtain freezing orders or preservation orders in the mainland against mainland companies, then we're actually seeing a pretty even split. While 82% of the applicants for these interim measures are foreign in nature, Only about 69% of the respondents are in fact mainland Chinese. And 31% of our respondents are actually foreign companies or foreign entities who have assets in mainland China. In addition to the interim measures arrangement in relation to preservation of assets and evidence and conduct, we also have a reciprocal arrangement on the enforcement of awards. The legal framework for enforcement of awards between Hong Kong and mainland China was implemented in 1999, but was recently updated in 2020. Now, the terms of that arrangement are similar to those that you would find in the New York Convention that allow for enforcement of awards so long as they meet certain mechanical criteria. And we have a strong track record of enforcement of HKIAC awards in mainland China. In fact, over the past 20 years, only 3 HKIAC awards have not been enforced in mainland China. We also have significant expertise in China-related disputes. We've already talked about the interim measures arrangement, and we've talked about enforcement of awards. However, to give an idea in relation to our level of expertise, each year between 10 to 16% of all of our disputes deal with Chinese parties that are state-owned enterprises. And we have, in fact, the largest caseload involving Chinese parties amongst all arbitration institutions outside of mainland China. We also have multilingual capacity, and between 10 to 20% of all of our cases are conducted in Chinese or in English and Chinese. And HKIAC also has a significant amount of experience in investment treaty disputes. We have a vast amount of experience in administering cases that are under the UNCITRAL rules, regardless of whether those are commercial arbitrations or investor-state arbitrations. We also provide administrative services, and we have in fact provided administrative services in 2 investment treaty arbitrations which took place under the UNCITRAL rules. We provide free hearing spaces for cases which involve a party which is on the OECD's developing countries list. And our legal staff and governing board members have significant and substantial experience in investor-state disputes. We offer a tribunal secretary service, which you will commonly find in investment treaty arbitration. And for disputes which deal with investor-state mediation, such as the CIPA between Hong Kong and mainland China, we are a designated mediation institution for disputes between a PRC investor and the government of Hong Kong. Now, I want to talk very quickly about our 2018 administered arbitration rules, which are a state-of-the-art modern set of arbitration rules for commercial arbitration between parties. And we have put a lot of effort into developing the 2018 rules to ensure that we are fulfilling 4 key criteria: that we are saving costs, that we are saving time, that we're providing efficiency in complex arbitrations, and that we're able to keep the rules up to date with recent developments in arbitration. Talk quickly about cost-saving measures. We offer an arbitrator fee choice system, and one of the few sets of rules in the world that allow for this, where you can choose to compensate the arbitrators either on the basis of hourly rates or on the basis of the amount of dispute, or what we call an ad valorem system. We provide a cap on arbitrator hourly rates of approximately $800 or 6,500 Hong Kong dollars per hour. That is a significant cap, and we are one of the lowest in the world in relation to that cap. In terms of our emergency arbitrator provisions, which is a procedure by which you can obtain interim measures from an arbitral tribunal or an emergency arbitrator, we also cap the total fees that can be charged by an emergency arbitrator. And again, we offer the tribunal secretary service, which allows HKIAC staff members to act as tribunal secretaries. And what this means is that the tribunal secretary can do a lot of the administrative work, which normally would be done by the arbitrator, and therefore allow for that work to be charged at a much lower hourly rate than what the arbitrator would charge, thereby reducing costs, which are eventually passed down to the parties. In respect of time-saving measures, we have an early determination procedure, which allows for unmeritorious or vexatious claims to be kicked out, or for clearly obvious claims to be dealt with in an expedited manner. We have an explicit and express time limit for issuing awards in our 2018 rules, which requires arbitrators to issue awards within 3 months of closing proceedings in arbitration. We also offer an expedited procedure for disputes which are under Hong Kong $25 million. And this expedited procedure is a shortened procedure which allows for the issuance of an award within 6 months of constitution of the tribunal. And as I mentioned earlier, we also include an emergency arbitrator procedure, whereby if a party needs to seek urgent interim measures from a tribunal, we can appoint an emergency arbitrator within 24 hours of the request, and that decision by the emergency arbitrator will be filed within 14 days of their appointment. Now, like I said earlier as well, one of the things we're most proud of in the 2018 rules is our efficiency and ability to deal with complex arbitrations. Now, we have multiple provisions in our 2018 rules that allow for various complex arbitrations, such as what you would see, for example, in a construction arbitration, and allow for example, the consolidation of 2 or more arbitrations, to allow a single arbitration to be commenced under multiple contracts, to allow additional parties to be joined to an arbitration. And if none of those provisions apply, to allow for multiple arbitrations to be conducted in a concurrent manner so that one arbitration can be dealt with instead of multiple arbitrations. And this is one of the things which is the biggest time and cost saver for arbitrations which are under the 2018 HKIAC rules. The complex arbitration provisions in our rules allow for every single scenario. And even in those scenarios which are not allowed, allow for a fail-safe in a concurrent procedure. Finally, we made sure that our 2018 administered arbitration rules stay relevant to recent developments in international arbitration, whether this means the use of, for example, alternative dispute resolution as outside of arbitration, such as mediation or adjudication. We allow for the use of, for example, our med-arb clauses, which allow for arbitration and mediation in a single clause. We have addressed the need for third-party funding in international arbitration and kept that in line with developments in Hong Kong in respect of the allowance of third-party funding in international arbitration, allowing for and requiring disclosure of third-party funding and third-party funders in arbitration. Our 2018 rules also encourage effective use of technology, such as allowing the delivery of documents for an online repository system, as seen in Article 3.1, and also encouraging the arbitral tribunal to make use of technology, as we've seen with the increased use of virtual hearings in Hong Kong and in HKIAC arbitrations. Now, what does that mean for HKIAC, Hong Kong, and the Belt and Road Initiative? Well, as I mentioned earlier in the presentation, we have the largest caseload of involving mainland Chinese parties outside of mainland China. 40% of our caseload consistently comprise of parties from mainland China. 30% of our cases involve a party from a Belt and Road jurisdiction. 7 to 16% of all of our mainland Chinese parties year to year are state-owned enterprises. And approximately 20% of our cases are dealt with either in Chinese or bilingually in English and Chinese. As I mentioned before, Chinese law or PRC law was our 3rd most preferred governing law last year. And we are currently administering various different construction disputes under the Belt and Road. For example, one of the disputes that we've dealt with recently dealt with a contractual arrangement between a Malaysian company and a mainland Chinese listed construction company and a Southeast Asian government to build, own, and operate a project through SPV. And that eventually went to arbitration administered by the HKIAC. So in relation to construction projects, particularly outside of Hong Kong and in Belt and Road countries, you will find Hong Kong and HKIAC to be a very good neutral ground with a lot of experience with both mainland Chinese and international parties in respective construction disputes. Now, I've also talked about both our arrangement on enforcement of awards between PRC and Hong Kong and the fact that only 3 awards were refused enforcement in mainland China, as well as the arrangement on court-ordered interim measures, which came into force in 2019, meaning that Hong Kong is the only jurisdiction outside of mainland China where you will be able to get interim measures. We also have a lot of support in place for the Belt and Road program. We have a Belt and Road Advisory Committee, which covers the spectrum of Belt and Road projects, including specialists from construction companies and construction arbitration. We have a resource center, which provides for a significant amount of information on both HKIAC, as well as the Belt and Road Initiative itself. And we have an outreach program, not only with mainland China, but also with other BRI jurisdictions. It's just an example of those current members of our Belt and Road Advisory Committee. And you can see we have members not only from major law firms which deal with construction, but also major construction firms themselves, as well as other legal experts and financial experts in relation to Belt and Road development. So we deal a lot with projects, large-scale infrastructure projects, which are led by Chinese state-owned enterprises, or which involve Chinese financing, involving both emerging economies, which deal with multiple parties, and which deal with multiple contracts. And many of our provisions of the 2018 rules, which I discussed earlier, are designed specifically to allow for the large scale and the various complexities which arise out of these large-scale infrastructure projects. And we also know that in relation to disputes which may arise out of the Belt and Road Initiative, arbitration is by far the most effective and widely used dispute resolution method in these sort of high-value cross-border transactions. In relation to HKIAC, we have, again, a strong track record in terms of cross-border enforcement. We are Hong Kong as a neutral and an independent forum, and we have a lot of sector expertise, particularly in the construction industry. And just as a final note, in respect of the other aspects of an expertise that HKIAC is able to bring in relation to Belt and Road disputes, we note that this is limited not just to Hong Kong. And we note that the Belt and Road actually spans a significant number of countries, and that there may be arbitration, or there may be parties, or there may be reasons why an arbitration institution outside of Hong Kong is chosen. But we also have concluded multiple different cooperation agreements with many different countries, both in Asia, but also Europe and Africa, in respect of arbitral institutions, and for example, Mauritius, in relation to in Mongolia, in Malaysia, in Cambodia. We have in Myanmar, we have many cooperation agreements signed with other arbitration institutions where we provide support. We provide administrative support and and information support for a lot of these institutions around the world. Now, as I had mentioned before, Hong Kong is a significant seat for construction arbitration, and it is one of traditionally the strongest and historically the strongest seats for arbitration in Asia Pacific. HKIAC, with over 35 years of experience, has done a significant number of disputes which involve mainland Chinese parties, which deal with large-scale infrastructure projects that deal with significant construction projects that are both commercial and investor in nature, as well as investor-state arbitration arising out of large-scale infrastructure projects. So we have significant amount of experience dealing with both the Belt and Road and countries and jurisdictions in the Belt and Road. So when you are looking at choosing a seat of arbitration or choosing an institution to administer a dispute, which is under the Belt and Road, or which is dealing with a construction project in a Belt and Road country, you should keep in mind the structural advantages which Hong Kong as a seat will provide you, such as the interim measures arrangement, but also the institutional advantages that you will get from conducting an administered arbitration. For example, under the 2018 administered arbitration rules of HKIAC. Thank you again very much to the Dashun Foundation for inviting me to speak on this topic with you today. And if you have any questions, please do contact us either at arbitration@hkiac.org or by calling us through the contact numbers below. Thank you again very much and have a good day.